from UNISA?
Yes, Chief Justice.
In 2004, you had started working as a candidate attorney at the UNITRA Law Clinic.
Indeed, Chief Justice.
In 2001.
Indeed.
But once you obtained your articles, you went to work as a professional assistant at the LHR.
Indeed, Chief Justice.
And then how long were you with the Lawyers for Human Rights?
I was there almost for a year.
Was that in Umtata?
In Umtata, indeed.
All right. And then you moved to KZN?
From Lawyers for Human Rights in Umtata, I moved to Legal Aid Board in Queenstown.
Oh, yes, yes. Where you remained for just over 2 years?
Yes, indeed, Chief Justice.
Before moving to KwaZulu-Natal?
Yes, indeed.
Legal aid still?
Legal aid still in Umlazi.
And you remained with legal aid until 2008 when you decided to go to the bar?
Indeed.
Right. Is that where you still are?
That is where I am, Chief Justice.
So how many years have you practiced as an advocate?
If my counting is
about
not...
16 years?
Between 15 and 16 years, Chief Justice.
And you were an attorney for about 6 years?
Indeed, Chief Justice.
Okay. What kind of work have you been exposed to, both as an attorney and advocate?
The kind of work that I have been exposed to as an attorney at Lawyers for Human Rights, initially it was civil work before Lawyers for Human Rights entered into a cooperation agreement with the Legal Aid Board, wherein some of the criminal work that the Legal Aid Board was doing was transferred to Lawyers for Human Rights. Thereupon, I was introduced to criminal work, which I did until all the various stints which I had with offices of the Legal Aid Board, both in the Eastern Cape and in KwaZulu-Natal. So I was doing purely criminal work from the time the cooperation agreement was entered with Lawyers for Human Rights until such time that I left Legal Aid Board in Durban in 2008.
You have acted as a judge both in the Eastern Cape Division of the High Court and in KwaZulu-Natal, where you want to work now permanently.
Indeed, Chief Justice.
How many acting stints did you do in the Eastern Cape?
I had one acting stint in Eastern Cape, which lasted for about 7 weeks.
Just over a month. And what kind of cases did you adjudicate during that brief stint?
I had one criminal case which I presided over when I came there, and which I did not finish. And the JP then allocated civil work to me, which I did in Umtata, in Gqeberha, and in East London.
All right. Then shortly after your acting stint in Umtata, you were invited to act in this division. You want to join permanently?
Yes, indeed. While I was working there, I was phoned by acting Judge President Madondo to act for the session that was going to begin in 2013.
And
in 2023, I'm sorry, about 2030.
Then you went back for another session last year, well, 2 sessions. Two further sessions last year.
Indeed.
And another this year until June.
In fact, I had 3 sessions in 2023.
Oh, I see. So in all, you have 4 sessions.
In all,
in KZN.
In all, I've got 5 sessions in KZN.
5.
I was invited to act for the session which started at the end of July and ended sometime in August.
All right. Did you pick up any reserve judgments during your last acting stint?
I have a reserve judgment, Chief Justice.
How many?
It's one reserve judgment. It is one of the matters which I have referred to in my questionnaire.
Yeah, you listed 3. I take it you delivered the other 2.
The other judgments were delivered, but it was listed as a matter which was partly heard. I heard that matter during recess in July and concluded it. It is the one in which I have a reserved judgment. In fact, that judgment is with the researcher, and I got communication from her yesterday that she will be looking at it in the course of this week, going towards next week, and it should be ready for delivery sometime next week.
All right. What kind of work were you exposed to in the KwaZulu-Natal division?
I was exposed both to civil work and criminal work.
And you wrote judgments?
I wrote judgment.
Quite a few.
I wrote about, when I counted, if my count is correct, I wrote about 28 judgments in total, including the judgments in the Eastern Cape. The one that is with the researcher will be the 29th judgment.
Mm-hmm. Any reported? You've listed 4 reported judgments.
Yes, there are 4 reported judgments, and those mainly are those when I acted in the Eastern Cape.
Right. All right. I'm going to ask Judge President Boyo Hloti to put questions to you, if she has any.
Thank you, Chief Justice. Good afternoon, Advocate Kleti.
Good afternoon, JP.
Yes. How was your acting stints in both Durban and Pietermaritzburg?
I have found them enjoyable, JP. I enjoyed my time mostly in Pietermaritzburg.
Yes. And we can disclose here that you were very reluctant to make yourself available because you're still earning good fees. And as I understand it, you're waiting for the letter to appoint you as senior counsel.
Yes, indeed. I'm still waiting for my letters patent. I was very reluctant, but I reflected on the issue, consulted with my family, consulted with my senior colleagues in the profession, and upon reflection, I thought I might as well come when I still have energy and not wait until very late when my contribution might be minimal.
Yes. And I note in your CV that you have a passion for training.
Indeed, I have a passion for training, JP. I think that passion came from the difficulties which I had noted in relation to the time when I was at the University of Transkei, particularly with bookkeeping. Over time, I realized I was doing better than others in that subject. So I took it upon myself to help my fellow classmates. Later, when I had gone to do articles of clerkship, with Unitra Law Clinic. I still had that thing in me. Many people approached me. I assisted them. Over time, I realized I might as well do it because clearly a number of people are dependent on me. When I moved over to KZN, I was surprised that it continued to an extent that I remember one colleague of mine who was desperate to pass it. He had failed it 3 times. He came over from Butterworth, lived here in KwaZulu-Natal. I prepared him for bookkeeping. And when it was time for him to go and write board exams, he went over to the Eastern Cape and he reported to me later that he had managed to pass. Unfortunately, for the period in August, I was approached again, but unfortunately, I was working on second. I could not be able to help. But usually, both in the sessions in February and August, I usually assist candidate legal practitioners with bookkeeping.
And I saw that you continued with that. You still do, even though you're no longer an attorney, but
Yes.
an advocate.
Yes, I still do JP because I'm a member of the BLA. So by virtue of that, it is my responsibility to ensure that I continue to assist, despite the fact that I may no longer be an attorney, but an advocate.
Yes.
I also was requested by the Society of Advocates of KwaZulu-Natal to assist with tutoring in criminal law and procedure, and I have been doing that since 2021 to date.
Yes, and should we just add voluntarily? You are not getting paid for it.
Insofar as bookkeeping is concerned, I'm doing it voluntarily, but when the bar comes knocking to your door and say, would you be in a position to assist? You usually have to oblige, at least at the level of the bar.
Yes. Then the other thing that you seem to have assisted greatly is the issue of briefing patterns when you were either you are still serving or when you were serving in the bar committee. Can you tell us a bit about that?
Insofar as the question, this is one of the problematic issues which we as the bar, I would say in KZN, are grappling with. It's an issue that we have found there, and we have found people who grappled with, such as the late Advocate Mkhize and Judge TV Norman. When the late Advocate Mkhize passed away and Judge Norman was appointed to the bench, we took it upon ourselves to continue with that, to ensure that those who came late to the bar do not find themselves closing shop and going home. So to that end, I've worked with one of my colleagues in one project in which we introduced juniors to eThekwini municipality. I prefer not to mention the colleague that we pioneered that project where we introduced junior members to the municipality in eThekwini.
Thank you. And in acting in the KZN division, one of the great things that you have done for me as the JP in particular is that you agreed to do a criminal session on second in Scottbury, because that usually doesn't happen that we send acting judges out on second, but you happily agreed to do that.
I happily agreed to do it because I have got no difficulties per se presiding over criminal cases. And even if I did, when duty calls, you've got no reason to say no, even if it was an area of law I was not comfortable with. I was going to be duty bound to do it, but I found it easier to do it. I know the area. I've worked there before when I was working at Umlazi. I know the area well, so it was easy for me to agree to do that stint in Scottbera as an acting judge.
Yes. And I see from your CV you do quite a lot of matters in the land court.
Indeed, I do quite a substantial portion of matters in that court. Indeed,
Yes.
JP, yes.
So part of the skills that I would imagine, or something that might help that court, and I know that they go through that process, is mediation.
Indeed, it is mediation.
And have you had an opportunity to assist in mediating some of the matters?
No, JP, I haven't had an opportunity to mediate the matters, but it does happen that those matters at some point are so fiercely defended. I would mention a big matter that we had done with was a group of advocates and attorneys. Did it in Melmoth. It was a problematic land claim. That matter was resolved by way of a settlement. It was not tried. So when you deal with the land claims matters, sometimes you find those situations where the landowners are willing to talk, and you engage yourself in that painstaking process of having to negotiate with the landowners, ultimately come up with a settlement.
Yes. To go to the next question, I want to start with this one. Have you ever been found guilty of misconduct by any professional body from the time you started and up to date?
I have not been found of any misconduct.
Yes.
JP.
This then takes me to the objection by, I think, the LSSA about the judgment that we are awaiting at the SCA. But more importantly, the judgment by Kanka AJ. I had an opportunity to read it, and without going to what the SCA might say or not say, what surprised me was the fact that if you want to, perhaps let me rephrase and say, if you want to issue a court order against a legal practitioner, what is the usual way in which we do that?
It is set out in a number of cases, like the case of Black Sash and many other cases. And we had drawn this to the attention of the court, that the procedure that they sought to adopt was incorrect at two levels, both substantively and procedurally. But despite us drawing that to their attention, we were never listened to. The procedure is that as soon as that order is contemplated, a rule nisi is issued, calling upon that particular legal representative to show cause why that particular order should not be granted. That is what we complained about. That if this is the order that you are contemplating, this is the procedure that you should adopt, so that we did not have to find ourselves having to defend the claimants on this side while we have to defend ourselves on the other side. But that was never listened to. We were indicted there, convicted, and sentenced without trial.
Yes. I know that we're waiting for a judgment there, but my understanding from the discussions we had before you even made yourself available was that the one judgment was out and the SCA had, the appeal was upheld. And in your view, in our discussion, it was that judgment and the one that we're waiting for a judgment from were almost the same in all respects.
Indeed, if I would call these two judgments, Mavundulu and Luhluni judgment, the Luhluni judgment, the SCA deleted that order which related to us. for the same reasons we had complained about, that this is not the procedure. If for one reason or another, the order which is contemplated would be justified, then at least the procedure, which is an established procedure, should be followed. The SCA in September of 2021 deleted that order which related to us and found that there was no justifiable reason why that order should have been granted. Now, insofar as the Mavundulu judgment, if one looks at that judgment, particularly paragraph 66, the Honorable Judge there says, I am bound by the Luhuni judgment. That on its own, once that judgment was set aside insofar as we were concerned, it followed naturally that the Mavundulu judgment, at least insofar as the issue of whether that claim was frivolous and vexatious, it had to take that course too.
Yes. And then I'm not going to ask you about judgments, because from the ones that I have seen, I don't have issues. But maybe my final question is, what in your view are the attributes of a good judge? And highlight for me those that you might possess if you have any.
Judge President, there are many, but perhaps I might want to emphasize those that I might bring along with me if I am recommended for appointment. One of those is Ubuntu. It's courtesy. It's patience. A human being has 2 ears, but I recommend that one should be able to bring a 3rd ear, so that in a situation where you are in court, you have formulated a prima facie view on the matter which is before you. You would have enough patience not to listen to 2 ears in terms of the prima facie view which you took, but use the 3rd ear and allow a hearing, even if you have a prima facie view. So those are the attributes that if I were recommended for appointment, I would bring along with me.
Yeah. CJ, I know I said that was my last question, but there's just one more that relates to that complaint again. In the other matter where they say you did not hear it because it sounds as if you ran away from dealing with a matter. That matter, I was in Devon with you when that matter came and more papers were filed. You came to discuss it with me because the other side was ready to proceed, but the other one was not ready to proceed. Maybe you can just tell us briefly what happened there.
What happened in that matter, Hadebe J had granted an interim relief and issued a rule on the 8th of September of 2023. The rule was returnable on the 15th of September 2023, which that date happened to be the date on which I happened to be a duty judge in motion court. A day before the hearing on the 15th, heads of argument came in that matter to my chambers through my registrar. I was reluctant to accept those heads of argument, but I decided against not accepting them. I said, perhaps there is something that is said in them. I took them, I considered them. The insistence in those heads was that the matter was to proceed. That surprised me because the matter was not allocated as an opposed matter. So when the matter was called, counsel who appeared for the applicant insisted that she wanted the matter to be heard, while counsel for the other side said the matter was not ripe to be heard and it was not set as an opposed matter. So it was not possible that the matter could be heard. So what I did was in motion court has to be fast. I requested the parties to speak, and I stood the matter down to enable them to speak and craft an appropriate order. And indeed, I stood the matter down. When the matter was recalled, the parties had crafted the appropriate order, which was to the effect that the matter was going to be adjourned sine die. The respondent was granted leave to supplement its answering affidavit because there were expert reports which were filed by the applicant in the replying affidavit. So I granted them leave to supplement. And then the further order which I granted was one which said they had to approach the senior civil judge for them to allocate them a preference in the matter in view of the fact that it was an urgent matter. But the rule remained in place. I extended the rule until confirmed or discharged because I wanted to preserve the status quo in relation to the matter. I was then surprised to be slapped with a complaint when there is nothing I had done but to follow the practice directives of the division as I know the practice directive 9.1 and 9.2, which are instructive on a matter such as that one.
And the order was by consent?
The order was by consent.
Yes.
JP.
Thank you, Chief Justice.
Thank you, JP. Premier?
No, thank you. I don't have a question.
JP Mlambo.
Thank you very much. Good afternoon, Advocate Khiti.
Good afternoon, JP.
Am I correct that when you were at the Mlazi Justice Center, you worked with Mr. Velamdag?
Indeed. In fact, if I may explain that, at the time I was there, he was the regional operations manager.
Yes.
The person who was there as the Justice Center executive was Miss Zanele, the late Miss Zanele Msweli.
Oh, yes. Thank you. Your acting stints, all of them have not been term long. Am I correct?
Indeed, Judge President.
I just want your opinion. You want to be appointed permanently, but you've never faced a term-long judge's allocation. You don't think that could be an impediment?
Let me predicate my answer, Judge President, and say that it may well have been beneficial if I had acted for the full term, but I hadn't. I am confident that the 30 weeks which I had is sufficient. I have seen enough to be able to deal with the rigors of a judge.
Yeah. On average, this is my last question, CJ, in case I'm criticized. Okay. On average, how long has it taken you to hand down your judgment?
It varies, JP, and there are a number of reasons why. Some judgments, the turnaround time would be 2 weeks. Some judgments would be the full turnaround time, which is recognized in terms of norms and standards. But there are judgments where I had exceeded that time period, especially when I came back from the Eastern Cape and was acting here. That would be contributed by a number of factors. For example, there's one judgment which I have attached on my questionnaire, the judgment of Kentep. It took me quite a while to finish that judgment.
Yeah, I
And
think
I went-
Advocate Titi, let me help you.
Yes.
Cases come with their own dynamics.
Yes.
I think that's what you're trying to explain.
Yes, indeed.
All I want to know is what has been the average in terms of your judgment delivery time. You say sometimes 2 weeks, sometimes 3 months, sometimes longer than 3 months. But what average can we work on? 4 months, 5 months, 3 months?
2 months, JP.
2 months.
Yes.
Thank you very much. Thanks, CJ.
Thank you, JP. Commissioners on the virtual platform, do you have questions for the candidate?
No question from my side, CJ. Thank you.
Commissioner Bredenbach?
No, thank you, Chief Justice. No question.
Thank you. Commissioner Ngugaito?
Now, I just want to ask Mr. Klitsch whether the case you were discussing with the president is the case of Case Center versus Freddie and others.
Indeed, Commissioner.
No, so that's your explanation for that issue.
Indeed,
All
Commissioner.
right. Thank you, Chief Justice.
Thank you, Commissioner Ngugaito. All right. Short interview. We have run out of questions for you, Advocate Tliti. Thank you for making yourself available, and good luck. You're excused.
Thank you, Chief Justice.
Good afternoon, Advocate Harrison.
Good afternoon, Chief Justice.
How are you?
I'm well.
All right. You were born here in Johannesburg,
Yes, I was.
but then you went to study in KwaZulu-Natal. Why did you not study at Wits?
Because my
Oh,
family
BP.
moved to Durban.
Oh, I see.
And I grew up in Durban.
All right. And you studied BCom and LLB successfully at the University of KwaZulu-Natal. Was that the University of Natal? It would have been the University of Natal back then.
It was UKZN Howard College at
Our
the time.
college. Yeah. So in Durban.
In Durban, yes.
That's my alma mater too. You started out at the sidebar, was a professional assistant, worked your way up to director partner, and then decided to join the bar after how many years?
After
6 years?
Well, 6 years, including my
Including articles, yes.
Including my articles, yes. 1 year as a professional assistant, and then 3 years as, 3.5 years as a director of DITS Incorporated.
Yeah. And you've practiced as an advocate since 2000?
Yes.
Yeah. And your areas of interest, as appears from your papers, are the ones the judiciary has particular interest in right now. Not that I'm giving you any hopes or anything. You have a special interest in commercial litigation, and you do insolvency, company, tax, and intellectual property law matters by and large.
Yes, a lot of insolvency and a lot of company law as a result, yes.
Yeah. And you have sat in various insolvency inquiries.
Too many to remember.
Right. And you have been, well, you've done a lot of things for the Society of Advocates of KwaZulu-Natal, which you are currently serving as a secretary.
Yes, I'm honorary secretary at the moment, and I have been lecturing insolvency in KwaZulu-Natal since 2010, because we have some very peculiar local practices in Natal, the way we practice insolvency in the form of our notice of motion and things like that. So it's something that is unique to KwaZulu-Natal, and we tend to preserve it.
Good. And you continue to lecture to date?
I still lecture. I'm still part of the pupillage training. I will be lecturing the pupils within the next month as well, and I have lectured, as I said, since 2010.
Right. Your practice also includes a very thorny area of our law, the road, well, for our courts, road accident fund trials.
Yes.
You've acted for, I count 3 terms, sessions as they are called in that division.
I have.
How many sessions have you?
We split the sessions into 5-week sessions. So I have served 5-week sessions. So 25 weeks in total.
All right. And what kind of work did you do during those stints?
During those stints, three of the sessions, or 3 of the stints, were in the civil section, and the last 2 stints were in the criminal section, doing criminal law.
You've listed 6 judgments you wrote. Are those the only judgments you wrote?
No. I've written 27 judgments, but a lot of them have come out after the application was put in. So after my application was put in, so since the 1st of August, I've handed down 12 written judgments.
None had been reported at the time you completed this form?
None had been reported.
Any reported now?
Not at the moment, no.
Okay. All right. Now I'll stop here and allow the Judge President of the division to ask you questions.
Thank you, Chief Justice.
Thank you, Chief Justice. Good afternoon, Advocate Harrison.
Good afternoon, JP.
I understand that you were also recommended for the status of silk, but you still have not received a letter.
That's correct. We've been waiting for quite some time now.
Yes. And when you were acting in the division, how did you find the acting stints?
I had fun. They were enjoyable.
Yes. I don't want to tell the commissioners that we regard you as talking a lot in between the corridors, but that's why you had fun. Just on the insolvency and business rescue matters, indeed, that a very, very limited number of practitioners have expertise in that area, and I see that you've practiced in that area for quite some time. Have you done anything to empower other colleagues so that they can be able to understand that area of law?
Well, that's where the lecturing has come in. I lecture a specific lecture on both insolvency and then a separate lecture on business rescue to every pupil, and I've done that for every pupil since 2010. So by my count, it's about 280 pupils since 2010 have been lectured to by me on that, on business rescue, insolvencies and liquidations. In addition to that, in all of my current matters in which I'm currently involved, I either have a junior who is either a woman or a person of color in all of my insolvency matters that I'm currently involved. So that is also part of the empowerment and passing on the knowledge.
Thank you. And I must say that recently I had an opportunity to be invited by Advocate Makola SC. He's now the convener of the trial advocacy, and they had a whole week session training advocates for free. I was quite impressed by what the GCP does in relation to empowering upcoming legal practitioners. Have you ever had an opportunity to be part of those?
Well, I have done Pamula both last year, and then I assisted again this year. I also just did the records going back only to 2016, but since 2016, I've been part of the training of 142 pupils at the Durban Bar. And when I say training, I was involved in a training exercise. So I did what we call the method, and I was involved in training all 142 at one stage or another. So yes, I've been involved in that, and I've lectured and presented at Pamula.
And the acting stint relating to criminal law, when had you done criminal law before you did your acting stint? You did a term for criminal session?
Yes, I did.
Yes.
Prior to that, I had done what was in the old days the Prodeos. That was in early 2000, and I'd done a few Prodeos then. And prior to that, when I was still an attorney, I had done 5 or 6 criminal matters.
And are you happy with the work that you did and the judgments that you produced?
Well, yes, I am happy, but I've given leave to appeal on one of the sentences in one of the matters, and that was that's something that I believe that whilst I'm happy with my judgment, the state conceded that they thought there may be a prospect that another court may come to a different decision. And so on that, I granted leave to appeal.
Yes. And also during your acting, the one thing that I was particularly happy with, whenever you were done in court, before you reached your chambers, you came and reported that you were done. Is there anything else? And of course, I would give if there was. But that's one thing that was commendable, because people tend not to come and report that they're done, so that you can see if they can assist in any other way. So if you do get recommended, don't change that. Yes. And also the one area that you assisted on as part of the bar, I embarked on a project of doing appeals during recess by the bar. Maybe you can tell how you assisted there.
Well, in my position as honorary secretary, I not only helped to coordinate, but I also found colleagues at the bar who were able to help with criminal appeals. And so what we did over a period of 2 weeks, we organized that members of the bar, and always either people who had acted previously or senior members were then put with previous acting judges, so that we could deal with the backlog of criminal appeals. There were generally 2 criminal courts sitting per day, and with that, there were normally 2 or 3 appeals in each court. So if you do the maths, we dealt with nearly at least 40 criminal appeals during a 2-week period through the assistance of the bar and the bench working together.
Yes. And finally, on my side, Advocate Harrison, and maybe just to mention that because you stay in between Maritzburg and Durban, you did both Maritzburg and Durban, and whenever somebody was not available, you easily stood in for them.
Yes, it's because of the nature of my practice and the insolvency work that I do. Appearing in Maritzburg isn't a problem. So yes, it was an easy thing to do.
Yes. I did not see any objections from the professional bodies. They seem to be all complimenting. So the final question from me would be, if recommended, what value would you be bringing to the bench?
I've been a team player in a lot of sports teams, and I think that each one has their own value as part of a team. And I think that as a team player, I would be bringing commercial experience to the team that you're building in the KwaZulu-Natal division.
Thank you, CJ.
Thank you, JP. Do you have questions for the candidate premier?
No, thank you. Yes, CJ. No question.
JP Mlambo.
Good afternoon, Advocate Harrison.
Yes, good afternoon.
Am I correct that you've acted for a total of just over 3 months?
25 weeks, yes.
That's over 3 months?
Yes.
You've not had a term-long acting stint?
The longest session that I spent was this last session, which was I did back-to-back criminal sessions for 10 weeks.
Yeah. And you had 10 weeks acting stint?
Yes.
That's a term-long appointment?
Yes.
Okay. And what's your average turnaround time for reserve judgments?
It all depends. My average turnaround time is normally within 2 or 3 weeks, but there have been two that have taken a bit longer.
Thank you, CJ.
Thank you, JP. Are there questions from the colleagues on the virtual platform?
Yes, CJ, thank you very much. I do have 2 questions. Can I proceed?
Yes, please.
No, thank you very much. Good afternoon, Advocate Harrison. I'm not sure, am I audible?
Just repeat what you said. We didn't quite catch it.
Advocate, but nonetheless, let me just get into the question. The first question that I want to ask you, it is something that I'm happy that you are practicing in the area, and certainly we really need judges who really understand insolvency law. My question is on the thing that is happening in the industry currently. There is a question whether creditors that came after business rescue has been commenced, whether we can participate in a meeting called by the business rescue practitioner to consider the business rescue plan. I'm not really sure if you have seen the debate and what are your views in that respect.
I think that you've highlighted one of the lacunas in the business rescue legislation that has been identified for quite some time. That in insolvency, you have a formal procedure which is recognized under Section 44 of the Insolvency Act in order that claims can be properly registered and dealt with. And this then is a lacuna in the business rescue legislation, because who is to determine what is a creditor? Because what if the debt is disputed? This debate has been going on for quite some time and is generally having been dealt with on a case-by-case basis. For me to express a view as to where it's going to go is something that I think needs to be a development of our law, that we need to develop a mechanism in which creditors' claims can be properly listed and or debated, because bearing in mind that, as I said, Section 44 of the Insolvency Act has very specific provisions on how a claim is proved and how you can interrogate it. So I think we need to develop mechanisms to introduce that into the business rescue field.
Okay, Harrison. Let's forget about the Insolvency Act. We're talking about business rescue in Chapter 6 of the Companies Act.
Yes.
And in that particular chapter, there is a definition of affected persons.
Yes.
And creditors are part of the affected persons. So I'm asking you in that context, these are people that have been declared to be creditors. Now the question is, if they came as post-commencement creditors, are they entitled to participate in a meeting called for the purposes of ascertaining whether the plan should be adopted? This has nothing to do with the Insolvency Act.
No, I accept what you're saying. What I was talking about is that your question is about post-commencement creditors. Post-commencement creditors can only come about if there has been a plan has been put in place. But the point being that if you are a creditor, yes, you are an affected person, and yes, you must be heard. And we've had numerous cases, even in our division, on where creditors have been fighting about the right to be heard in those proceedings. So the answer is yes, we need to develop that area of our law.
Actually, there have been recent developments, but nonetheless, let me leave that question and go to another one. I see a lot of cases, a lot of judgments where people who ought not to be sequestrated are being sequestrated in Zimbabwe. What I want to ask you is, can a trustee bring a sequestration proceedings against a debtor without having first required the debtor to pay the amount? And here I'm taking you back to Section 8 of the Insolvency Act.
Sorry, Section 8 of the Insolvency Act are the deemed acts of insolvency.
Yes, the acts of insolvency. No,
sorry, I don't understand how you can ask whether a trustee can bring an action based on Section 8. The Section 8 is the deeming provision for deeming a person insolvent in terms of the Insolvency Act.
Okay, let me clarify the question. What I'm asking is, can the trustee bring an application for a sequestration using any of those acts of insolvency as a gateway to someone that they have not required them to make payment upon debt upon which the application is based?
The answer to that is obviously something which has been looked at for quite some time, and going back to the Baden-Horst rule, as to whether the debt is genuinely disputed or not. But if there is a debt and if there is an act of insolvency, then yes, you can bring those proceedings. You can invoke the provisions of Section 8 of the Insolvency Act.
But can that be done when a debt is not yet, or a request is not yet been made that the debt must be satisfied? Can you just go to court on sequestration first?
You would need one of the acts of insolvency first, but generally demanding the debt, if you look at, for example, Section 8B, that is where you have a nil bono return. You've already demanded that debt and acquired a right to exercise on it.
Let me leave it here, CJ. Thank you very much, CJ.
Thank you, Commissioner.
CJ, with your permission, can I just follow up on this?
Yes.
Because I don't think Advocate Harris is following what the professor says. The professor prefaced his question by saying that he has noted that there are people who are being sequestrated in circumstances where ordinarily they shouldn't be. And before a person could be regarded as insolvent, or the court can declare a person as insolvent, there is factual insolvency, but there is also commercial insolvency. Now, relying on Section 8, which is a deeming provision, there has to be an act of insolvency committed. And the professor is asking, is it possible for a person to be declared insolvent in circumstances where an act of insolvency in either form has not been proven, more especially because no demand would have been made to that debtor?
Yeah. The problem is that what has been, the way the question has been phrased has conflated sequestrations with liquidations, because commercial insolvency is something which we get under liquidations. That is a separate issue. But to answer the question about can a person be sequestrated, I think you need to go back to looking at the manner in which that sequestration occurred. And I'm very aware that when I lecture on sequestrations, that I remind all the people in KwaZulu-Natal of a very fine judgment in the Joburg division of Castleton versus Stride, which says that you have to have personal service of the papers because you are dealing with you're dealing with a status matter. So that in and unto itself is a protection against sequestrations. As to whether a person can be sequestrated before a demand has been made is entirely dependent upon the factual circumstances and the factual matrix of a case. and it is almost impossible to give a one answer that fits all.
I'm fine, CJ.
Thank you. Commissioner Hassan?
Thank you very much, CJ. Yeah, I'm over here. It's always good just to show you where we are.
Thank you.
Advocate Harrison, I take that both on paper and as you were just demonstrating a few minutes ago, your level of expertise in the field, particularly within commercial law and insolvency insurance, etc. It's interesting then that because you lecture and teach quite often that you haven't published or written any sort of papers, and I noticed that as a gap in your application. So I'm just interested into why that is, and then also you haven't had any reported cases, if I'm correct. That's my first question, CJ.
Okay. If you say reported cases, that is in terms of reported cases where I have been the judge. I have a number of reported cases where I have been involved as counsel. I've got at least 8 reported cases where I've been counsel. But as regards the question on my lecturing and publishing, I think the point that I'd like to make is that when we lecture to the pupils, we're lecturing about the law and its practice within that division. So we are dealing with, effectively, the historic position and the position of how we apply it in our division. That is not something that lends itself towards publication. As regards publishing, my answer to that is I'm a practicing advocate. I'm not an academic.
CJ, my second question.
Yes, go ahead, Commissioner Hassan.
Thank you. I take the point on the reported cases as counsel, and I did mean actually as an acting judge, which leads me to my second question.
Yes.
We have quite a number of candidates who are appearing before us today, many of whom have acted quite a fair amount. I'll just ask it, do you think that you've acted a sufficient amount of time in order to qualify you to, at this point, be appointed a judge?
The answer to that is yes. And I think the reason I say that is because a substantial part of the practice as a judge is motion court. And I'm not sure if you're aware, but in KwaZulu-Natal, liquidations and sequestrations are heard at the end of the roll. So if I can say that I have sat through motion court extensively over the last 24 years, I can say I have spent more than 10,000 hours in that court listening to all the cases that go beforehand. And as a result, my answer to you is yes, because I think that I have an extensive knowledge and ability in motion court, which is a substantial part of the practice as a judge.
Commissioner Pillay?
Thank you, Chief Justice. Good afternoon, Advocate Harrison.
Hi, sorry.
I heard you mention twice the need to develop the law to introduce certain mechanisms in the business rescue process. How do you see that development taking place?
It's going to occur at 2 levels. One is it's going to occur through the conduct of the business rescue practitioners developing their procedures for it. And secondly, through the courts testing whether those procedures are in fact stand up to scrutiny and are inclusive in incorporating all the creditors' claims.
All right. And then as a judge, if you were to consider a development of the law, of the common law, how would you go about doing that?
Well, first of all, I would hope that I'd have experienced counsel in front of me who would be able to give me good detailed heads of argument. And the way to develop the law is to take pieces of all the different cases that have gone beforehand, and what you then do is you put them together as a composite moving forward.
And where does the Constitution feature in this exercise that you're conducting?
Well, the Constitution would feature in that everybody has the right to be heard, and that everybody has the right to appear before either a court or, in this instance, a quasi-judicial hearing, which a meeting of creditors is in many respects.
Sorry, Chief Justice. I think I want to follow up. You see, because I don't understand now, Advocate Harrison. Because you want to develop the common law, but you are not telling us what is the role of the Constitution in the development of the common law.
Well, all I'm saying is I was asked the question, what is the role of the Constitution in all of this? And the Constitution preserves the right to be heard and the right to be seen. And I'm saying that this is also part of developing the law on business rescue, that you need to develop it.
I'm not asking you about the role of the Constitution in a hearing. The question of Commissioner Pillay is, what is the role of the Constitution in the development of the common law that you want to develop?
Okay. The role of the Constitution is the right to be heard, the right to be seen, and the right to have your debt or your dispute dealt with in a proper and appropriate fashion.
But have you never heard of Section 39 of the Constitution?
Yes, of course I have.
What does it say about the development of the common law?
We are enjoined to interpret it in accordance with the precepts of the Bill of Rights.
And I'm talking about the development of the common law, not interpretation.
Yes, but that's what I'm saying is exactly what you're saying is that the common law must be developed bearing in mind the precepts of the Constitution.
And the other thing I couldn't understand is the question by Commissioner Hassan. You say that in your CV, I've now looked at your CV, you say you also lecture. She then says, why don't you publish? You say it's because I'm a practitioner. But you are the one who told us that you are a lecturer as well.
Yes, I'm lecturing pupils during the pupillage program. I'm lecturing them as an advocate on the practice of insolvency and liquidations in our division.
Or you a trainer more like?
Yes, training. Yes, sorry, yes.
No, I understand that. I know what you're saying now.
Sorry, it's done by way of a lecture, but yes, it is training.
Yes, all right. Thank you, Chief Justice.
Advocate Harrison, the reason that I asked is because I picked up from your questionnaire that you've got very limited experience in constitutional and administrative law specifically.
Yes.
I just want to understand from you, do you not see that as an obstacle to you joining the ranks of the judiciary at this stage?
No, I don't. And the reason being, and if I can mention it, I've had there was a recent judgment that I handed down in a matter of Naidu formerly Padiachi versus Changing Tides. And that dealt with Uniform Rule 46A and the execution against property. And there were constitutional principles involved in that matter, and I saw myself clear to granting a judgment in which I set aside a sale and execution and ordered that the property be returned to the applicant.
And have you written a judgment in a matter involving enforcement of rights, of constitutional rights?
No, I haven't.
And you haven't litigated one either?
No, the only constitutional court matter that I have been involved in was the constitutional case on execution against schools, the Kenmont school case. That's the only constitutional court matter I was involved in.
Thank you, Chief Justice.
Commissioner King?
Thank you, Chief Justice. Advocate Harrison, firstly, I commend you for applying. The bench would be enhanced if you were to have taken silk. And I just wondered whether you had applied for silk, and if you hadn't, what your reason for not applying for silk was.
Okay. I applied for silk in 2023. JP, if I'm not mistaken, my silk was approved by the JP in June last year. And I have been one of those that have been waiting since then for the conferment of silk.
Thank you. That answers the question. If I may, my second question then, going back to the discussion with the other commissioners, in a business rescue situation, and it's not my area of expertise, but my understanding is you've got a statutory regime which is aimed at protecting the rights of various stakeholders. And you can get a lot of intimidation in that environment, I'm sure you're aware. You can get predators who are secured and unsecured, and some treated in a way that they would consider to be very unfair. And you've got various rights of Audi already built into the process. Now, if you were confronted with an application where you're now going to develop the common law, what sort of values would you be looking to ensure accorded with the constitutional values in that scenario?
The first thing that I would be looking at is protecting the rights of workers, because the employees are normally the ones who suffer the most in these situations. And in doing so, that then also recognizes part of the business rescue, in developing business rescue. For a business rescue to work, you need to have those employees knowing that they are secured, and for them to know that if they work, they will get paid. So the development would be in protecting, would be if I can call it, a ground-up approach. Start with the employees, making sure that they are protected and that their jobs are secured in the business rescue, so that if the business rescue is to go further, the business has the necessary wherewithal to continue with the business rescue plan.
Thank you.
Deputy President Zond.
Thank you, Chief Justice. Good afternoon, Advocate Harrison.
Yes, good afternoon.
My question relates to paragraph 6 of your questionnaire. It's page 7 and 8 of the paginated bundle.
Yes.
Now, 6.1, you indicate that you appear in tax court. Now,
yes.
When you appear in tax court, is it in relation to Tax Administration Act or VAT, or what tax cases do you do?
Currently, I'm involved in both
Okay.
income tax and VAT matters, and I have actually got both income tax and tax matters set down in front of the tax court in November of this year.
And then 6.2 of the questionnaire, you say your practice is about 1% of your practice consists of criminal law. Have you ever appeared in criminal court?
I did previously, as I said, in pro deos,
Okay.
but that 1% is there because within the Insolvency Act from section 135 onwards, you have various criminal sanctions, as well as in terms of the, so you have criminal sanctions for conduct where an insolvent has breached various statutes. And I put that 1% down because I'm involved in advising on that from time to time.
But
not appearing.
Yeah, that's what my question was directed at, to establish whether have you ever represented an accused person in court and run a criminal trial?
Yes, I have, and I've done it in both pro deos, and I did it as an attorney.
Okay, that's great. Thank you. No further questions, CJ.
Thank you, TP. Follow up?
Yes, it's me, Chief Justice. I wanted to ask Advocate Harris, have you attended any judicial skills training course?
I did in January this year. It was a very, very interesting and useful course. In fact, if you look at the judgments that I put forward, one of them was Newport and Nandela. I'd like to think that that judgment was influenced by that course, because after I had done a first draft of that judgment, I went on the course and then completely redrafted the course, redrafted that judgment, because I believed that I wanted to incorporate a lot of the tips and the insights that I'd got from that judicial course in that judgment. So yes, I have been on it. Yes, I found it useful. And there is the product in Newport and Nandela.
Thank you, Chief Justice.
Thank you. We've reached the end of your interview, Advocate Harrison. Thanks for making yourself available. Thank you.
Thank you.
You're excused.